morning to you all. It's wonderful to have such a large turnout here today representing such a wide range of businesses from across private and public sector. To give you an idea of who's here, we have people from financial services, charities, education, technology, sport, health services, property services, business services, hospitality, local and national government, and government agencies. So you can imagine when I was trying to pitch this and picture my audience, it was such a wide range that today is very much going to be a general view of data protection today, what happened in the past since GDPR, and looking forward to the future. Many of your organizations are based here in Ireland, but some do have cross-border operations. Others are in the UK, and some of these organizations here today have an international presence. So let's have a quick look at today's agenda. To begin with, because we do have some first-time attendees, I'll give you a brief glimpse of calQrisk, who we are and what we do, and then we'll get straight into the presentation, beginning with a retrospective of 5 years of GDPR, looking back at some statistics and trends that have emerged since its inception, and then we'll consider data protection as it looks today in the EEA in the UK and in some other international jurisdictions. And finally, we'll examine some emerging issues that are interesting from a data protection and privacy perspective. So who are we? We're a team of risk and compliance professionals and members of the Institute of Risk Management, the IOB, Compliance Ireland, the Institute of Directors, the ACCA and ISACA. And we're not all members of it all, but we do like to keep our skills sharp, to quote Jerry, and keep a finger on the pulse of what's happening in our respective industries. So we make a governance, risk and compliance solution called calQrisk. It's a cloud-based software solution. It's a single point of reference for risk and compliance control environment information. It contains a knowledge base of risks and associated controls across various categories. It's used by over 2,000 users in regulated firms and others, including brokers, fund management companies, fund administrators, over 100 credit unions across the island of Ireland, charities, sports organizations, housing associations, aviation, public sector, solicitors, schools, maths and colleges, and I think you're all represented here today, so that's great. So here is an introductory timeline. We're 2 days shy of GDPR's 5th anniversary, and so much has happened in the realm of data protection in the last 5 months, let alone in the last 5 years, that we'd need a lot more than 30 minutes to even list it all. The main thing that struck me as I was compiling research for today was that despite the efforts of GDPR and other similar international initiatives, people across the world are more under threat in terms of data protection and privacy than they've ever been. Regulation, even at a federation level, such as GDPR, it's not enough to mitigate the risk from the continuously emerging global players who are developing, utilizing and making available ever more powerful technologies that can collect and analyze and combine and pass on information at phenomenal speeds and mind-boggling volumes as more and more of us entrust our personal data to the cloud. So when the GDPR was enacted in 2016, it set the European Union up as the data protection poster child for having drafted the most comprehensive attempt to regulate personal data processing by public and private sector organizations. But by the time it was implemented on the 25th of May, 2018, the cracks were already beginning to show. We'd already seen the Facebook and Cambridge Analytica story that broke in April that year, and commentators were beginning to suggest that while its heart was in the right place, that GDPR was going to need to flex some serious muscle to bring the biggest offenders to heel. The intention in Europe was to follow up quickly with the ePrivacy regulations. The European Data Protection Board even released a statement to that effect on GDPR Day, but 5 years later, consensus hasn't been reached, so we're still waiting on it. You can read the latest draft and related publications on the European Data Protection Board's website. As we go along today, you'll see there are links in the bottom of the slides, and there are links to useful information, informative documents, and there's an Easter egg in there somewhere for people who want, if you want to go and find it. SpongeBob SquarePants fans might enjoy it, because I did consider saying 5 years later in the voice of the French narrator, but I thought better of it. So here we go. We'll start by looking at some statistics that have been generated over the lifetime of GDPR. Because an important part in any anniversary celebration, I suppose, is to look back, but we won't be dwelling there for too long. On this first graph, we see the number of complaints to the Irish Data Protection Commission since 2018. The blue bars represent the GDPR complaints, the green bars the total of all complaints, including those made under previous data protection legislation. And always most interesting, I think anyway, is the type of complaint that consistently tops the charts, and that's data subject access requests, DSARs, and that's represented here by the yellow line. So here we go, practical tip number 1, 5 ways to reduce your DSAR risk. Minimize what you process. That is what you collect, you store, you back up, etc. Because if you don't have it, you don't have to give it, to give it back. And if you don't already, get to know the data that you're processing. Ask questions like what, types, categories of data and the format, where, is it paper or electronic, is it in a database, is it in a backup, and etc. Why, so what is your purpose and what's your legal basis, and who are you in the processing? Are you the controller, a co-controller, or a processor? And who are you sharing data with or transferring it to? Your record of processing activities, your ROPA, will help you with this. So make sure your teams keep it up to date as the departments add new processing activities. Even if you're one of the minority who's not obliged to maintain a ROPA, consider doing it anyway, because it really will give you a very clear picture. So then review your data retention and your deletion policies and processes. Are you actually doing what your policy says you're doing? If you're not, get on that straight away. Have and communicate a clear procedure for lodging DSARs. Data subjects are not obliged to follow it, but chances are most will, and that will make your life easier. And train and retrain your people so that they can recognize a DSAR and escalate it appropriately. So moving on, we're now looking at data breach notifications for the period. Total notifications are indicated by the blue bars. The grey bars represent the number of valid breaches. The decline in total notifications that we saw in 2021 has continued again through 2022. And the decline in non-breach decisions we've been seeing since 2019 actually reversed in 2022. And the yellow line represents the number of breaches that arose from unauthorized disclosures as a percentage of the total. And they consistently come in top of the list of breach types, topping out in 2020 at 86%. They've fallen to less than 62% in 2022, but they're still the top offender, if you like. Our practical tips for this slide comes from the Data Protection Commission, and it's a document called Avoiding Data Breaches. They were written for COVID times, but they're equally as relevant today, particularly as many of us continue to work from home or on a hybrid model. So here on this graph, the blue bars represent the total number of complaints made under the ePrivacy Directive. And I've broken it down into email marketing, which is orange, telephone marketing, which is gray, SMS marketing is yellow, and for the first time, cookies made an appearance, and that's there in 2022, the little turquoise bar. So just as I did last year, I've included this more so as a reminder that GDPR is not the only data legislation that we're subject to. Sticking with the theme of complaints for just a little longer, it's no secret that the Irish Data Protection Commission has their work cut out for them. Ireland is home to so many big tech companies. I like to call them Meta, etc. Our Data Protection Commissioner is watchdog to many of the world's social media giants. And between May 2018 and December 2021, 969 valid cross-border complaints were received, for which the DPC was the lead supervisory authority. These complaints involved more than 75 different data controllers, but as you can see from this table, 86% of those complaints were against just 10 companies. So no real surprises there. So here I've sourced two graphs. This is the first showing EU cumulative GDPR fines, and I've taken them from Enforcement Tracker website that's managed and maintained by the international law firm CMS. So this first one shows monetary value in euros. It's clear that while 2021, particularly the latter half, was a record year with well over €1 billion in fines imposed, yesterday's timing, 1.2 billion fine by the Data Protection Commission on Meta for data breaches related to cross-border transfers from the EU to the US would push May 2023 literally off the charts had I included it. So this view shows cumulative fines by number. There looks to be an obvious flattening of the curve this year, but it's because the cutoff reporting date is the 1st of March. So that will, I'm sure, even out or even spike a little bit once those numbers are recorded. And you'll find them there. There's the website down there, the Enforcement Tracker Report. So next slide. This slide is the last in the 5-year overview, and one of the most interesting, I think, at least from a risk management perspective. Okay, so it's a list of 9 categories to which the justification for each of them, each reported fine handed down by a European Data Protection Authority over the course of the life of the GDPR can be attributed to one of these 9 categories. The first 5 and the last one are listed in order of frequency, and the other 3, I've arranged them in the order I think they might fall in, but I don't take my word for it. So to me, this reads like a data protection risk list, very similar to the one you'll find in calQrisk knowledge base, and not a bad place to start if you wanted to identify risks to your organization that you may not have considered previously. Here we have some data protection news. I should have a little jingle. Some of the highlights over the past 12 months. For the first one, we need to go back a little further to July 2021, when the Joint Committee on Justice laid their report on meeting on 27th of April 2021 on the topic of GDPR, in inverted commas, before the Dáil. That 27th of April meeting was a public stakeholder engagement attended by the Data Protection Commissioner, the Irish Council for Civil Liberties, the Austrian data protection activist Max Schrems, who we all know from Schrems 1 and Schrems 2, and solicitor Dr. Fred Logue, who I'm sure a lot of you have met on the data protection conference circuit. There's a link to the report in the footer, and there's also a link to Fred's opening statement, which is very interesting. So it wasn't until October 2022 that the report made it to a Dáil debate. And one of the main topics of that debate was the ineffectiveness of GDPR enforcement by the Data Protection Commissioner. The second item is the Irish Council for Civil Liberties. They published a report this month on the EEA data protection authorities, and they've named it 5 years, GDPR's crisis point, which more than hints at the tone of the document. But some of the issues that they raised are the relative underfunding of 10 national data protection authorities, despite a rising combined data protection authority budget for the EEA region. They also raised the fact that no other GDPR enforcer can intervene if a lead authority asserts its lead role in cases against firms that have their European headquarters in its country. They can only intervene when the lead authority delivers a draft decision for them to comment on at the European Data Protection Board. Now, this is a particular issue for Ireland's DPC because of its lead authority status with Meta, etc., and the rapid developments in their use of new technologies such as artificial intelligence. Using amicable resolution for repeat offenders or for matters likely to impact many people, this contravenes the European Data Protection Board's guidelines, but it's how the DPC chooses to conclude 83% of the cross-border complaints that it receives. So problematic area there. The third story is one I mentioned in last year's GDPR Day webinar, actually, about the government's plan to introduce facial recognition technology for Gardaí. I believed it was still under discussion, but I came across one published source, which I haven't confirmed yet, that reports it's already been included in an amendment to the Recording Devices Bill, which is currently going through the legislative process. But I will try to confirm that and, give you the up to the minute information on that, and we can circulate it with the resources afterwards. It's worrying because Labour and the Green Party have called for a standalone law on the software due to its complexity, and I agree with that point of view, particularly from the aspect of risk to the individual, from mass surveillance, data combining, and the potential for further processing. as a result of function creep, which could easily happen in a situation. The next two items, I couldn't leave them out, are a report on the conclusion of 3 separate inquiries into Meta Ireland. So the first two concluded in January this year with fines of 210 million for breaches relating to Facebook, and the other for 180 million in relation to Instagram, both for insufficient legal basis for processing. And it was also issued with a compliance order to bring its data protection operations into compliance within 3 months. And then yesterday, a little over 3 months later, Meta is fined again, this time for continuing to transfer personal data from the EU EEA to the United States, following the Court of Justice of the European Union judgment in DPC versus Facebook and Schrems. So this fine is an eye-watering 1.2 billion. I'm sure we've all heard it on the news hour after hour since it broke yesterday morning. And it reflects the gravity of the infringement and the European Data Protection Board's determination that an administrative fine would be imposed to sanction it. Meta have also been ordered in this ruling to suspend any further transfer of personal data to the US within 5 months, and within 6 months to cease unlawful processing, including storage in the US, of EEA EU users' personal data that may have been transferred in violation of the GDPR. So we'll watch this one intently, because Meta has already released a statement saying that they intend to appeal the decision. Now, let's look to the UK and to what's happening there from a data protection perspective, because as we all know, after Brexit, there were worries that UK would not receive adequacy, but they did, and that we all breathe a sigh of relief. But the divergence risk I spoke about last year hasn't yet materialized, but there are certain uncertainties due to changes in government last year. So the original Data Protection and Digital Information Bill was abandoned and then reforged earlier in the spring to the Data Protection Digital Information #2 bill, which is now at committee stage in the House of Parliament. And one of the key changes arising from this legislation, if it is passed, will be a strengthening in accountability. So organizations will no longer be required to appoint a DPO, but will instead have to appoint a senior responsible individual from among their board or senior leadership team. This person doesn't need to be a data protection professional, because they can delegate to a subject matter expert, who would essentially be a DPO in all but name. And the senior responsible individual, or SRRI as you might have heard called, will be held personally accountable along with the organization in the event of a significant data breach as a result of their negligence and or inaction on their part. Another potential change in the UK is the introduction of a mandatory data protection complaints policy. So while this makes good sense for business, it also should make the ICO's life easier, in that complaints that are handled well will be less likely to be escalated. So if it's adopted as it is today, we'll see a lighter touch approach to documentation. For example, the DPIA will be replaced with something shorter and more concise. A bigger issue for organizations domiciled or with a presence in the UK is the retained EU law revocation and reform bill, a mouthful. It proposes substantial changes to the body of retained EU law in UK domestic law, principally to sunset most of the retained EU law by the end of 2014. And there are about 4,000 pieces of legislation that need detangling from their domestic law. And the general consensus among data protection professionals that I've read or listened to is that the UK GDPR is likely to be in place for the long term, and only the relatively minor changes brought about by the data reform bill will happen. And at the end of last year, the ICO introduced new guidance on transfer risk assessments in a move away from the EDPB, so that's European Data Protection Board guidance. And there's a link there and you can read it at your leisure, because trundling through, we need to get on with this. So looking out to Europe, there's a European data strategy in place at the moment, which includes significant initiatives that could have significant impact on data protection. So the Data Governance Act is cross-sectoral and aims to make more data available through the regulation and reuse of publicly held protected data. Increased sharing by regulating novel data intermediaries. So these are organizations who will establish commercial arrangements between data holders and data users. And this will also encourage the sharing of data for altruistic purposes. I practice that word. So both personal and non-personal data are in the scope of the Data Governance Act. And wherever personal data is concerned, the GDPR will take precedent. In addition to the GDPR, the inbuilt Data Governance Act safeguards have been designed to increase trust in data sharing and reuse, and essential, they say, to ensuring that more data is available on the market. Frankly, it makes the hair stand up on the back of my neck, but we'll watch it intently and see where it goes. The second leg of the European Data Initiative or Data Strategy is the Data Act. So this was proposed in February 2002. So we were aware of it this time last year. Its scope is very broad. It includes the design and access to data that's generated by connected products or generated during the provision of related services to the user of the connected product. So basically your smart devices, your appliances, your phones, virtual assistants, your car, the Internet of Things, but also worryingly the Internet of Bodies, which is coined by an American data expert. So these include medical devices such as pacemakers, smart pills, Bluetooth cochlear implants, and wearables like Fitbits. And the worrying thing about this, these are also marketed and worn by children. So all these things have mixed data sets and they contain both personal and non-personal data. So users should be able to use these devices in the least intrusive way possible, if not anonymously. The European Data Protection Supervisor and the European Data Protection Board have published a joint opinion on this. So the link is there and you can also have a look at that. So speaking about the European Data Protection Boards, is such a useful resource, and they publish some very useful guides, a number of which I've already referenced today, but this particular one is very handy. It's an online guide for small businesses. It contains clear, useful information that will help with understanding data protection basics and with achieving and maintaining compliance. And although it's not the intended use, I think that this guide would be very useful for individuals within an organization as a reference guide and as a support to their ongoing data protection training. And a final tip, and this time in relation to deploying new technologies, because we couldn't leave today without talking about new technologies. It's all over the news. When it comes to artificial intelligence, the worrying thing is that it was going to reflect the entropic nature of human thoughts. Okay, so biases, tropes, etc. And so the experts believe that a philosophical input is required as well as a regulation. And fairness by design and privacy by design are paramount. But even the creators of these technologies are worried about their effects on society in general. So we do well to be cautious about our use of them. Do your data protection impact assessments if you're considering it. I'll circulate a data protection impact assessment prompt sheet afterwards. If to anybody who would like one, just let us know. Technological advances such as artificial intelligence, machine learning, and big data pose new threats and challenges for data protection and privacy. Before deploying any new technology, applying appropriate data protection safeguards are essential to ensure that personal data are processed in a lawful, fair, and transparent manner, and that the rights and freedoms of the individual are respected. Okay, so remember that data protection impacts assessments are mandatory for any high-risk processing projects, such as those involving large-scale or systematic uses of personal data, biometric or genetic data, automated decision-making, or vulnerable groups of data subjects. And they help us as data controllers. You know, they might be a pain to do, and you've got to get, you know, practically the whole organization involved because you need input from every department. But they help us as data controllers to identify and minimize those data protection risks, to plan for the implementation of any solutions to those risks, as well as assessing the viability of the project at an early stage. They also help us to communicate effectively with the individuals whose personal data is, you know, we're going to be processing through these technologies, and to demonstrate our compliance with the General Data Protection Regulation. If a data protection impact assessment doesn't identify safeguards that effectively mitigate any residual high risks, then you must consult the Data Protection Authority before proceeding with the project. So what about the future of data protection? We've spoken about Ireland and the UK, a little more here on the EU. We're seeing more and more harmonisation, coordination and cooperation at a regulatory level, and a move away from a lead authority concept. So, you know, instead of Ireland being overwhelmed with all of their lead authority, I think we'll see more coordination and cooperation with the other data protection authorities across Europe. Record fines. So this one happened as I was finalizing my slides yesterday with the meta fine, but fines are going to go up. The data protection authorities' teeth are getting bigger, and they're taking a much more strict view of data breaches. Pooled expertise. So you know, using the same advice across the EEA, using the same standards and rationale across the EEA, and cooperation on strategic cases. And that, as I said, would pull work away from Ireland and relieve a little bit of the pressure. So internationally, we'll see an acceleration of breaches and cyber attacks. Look, we only have to open our emails every day, and more phishing emails, and they're getting by our firewalls, if you like, or our protections that we put in place on our servers. And I suppose AI has a role to play in this as well, because now these phishing emails will not long be, you know, bad English, poor grammar, but they'll be, you know, practically indecipherable from a regular email. So you really need to, I suppose, educate your staff, because as we all know, you know, the top risk is that somebody's going to click on something and then your whole network is going to be at risk. The expectation is also that by the end of 2023, that ad tech and market tech will be effectively regulated globally because of initiatives in the US, California, Virginia, and lots of other states have put consumer protection, data protection initiatives in place. But there is talk out there about a federal US data protection initiative, but again, it's only talk at the moment, and I haven't seen anything concrete about it yet. So that's it for me, except now it's over to you and your questions. I'm sorry for bombarding you with all that information. I know it was at breakneck speed, but I've given you all the links to all the resources so that you can go back in your own time and investigate further, you know, things that are of particular interest to you.
That was brilliant, Fiona. Thank you so much.
Not at all.
So we actually have a couple of questions in the Q&A box, and if anyone has any questions, feel free to pop them in. It'll be on the bottom of your screen. So we have one from Mick, and they want to know what's an invalid breach?
Oh, it's a breach that's so somebody's reported a breach, but it's not actually a breach under the GDPR. So, you know, if somebody was being overly cautious and reported something, but the Data Protection Commissioner came back and said, you know what, thanks for doing that, but it's actually not a breach. They did put a mechanism in place. It was a questionnaire that you have to go through before, you know, as you're reporting breaches. That did filter out a lot of those. So I guess maybe the rise is due not so much to people over reporting, but maybe more breaches, and just so that the portion of unvalidated breaches has gone up as well.
Perfect. Thank you. There's another one. So do we know what happens with the fine money and what it's used for?
No, but I could FOI it and let you know. I'm sure it's pulled back into fund the budgets for the data protection authorities and the European Data Protection Board, and you know, education initiatives and things like that. And these people also need to be paid. So I don't know. I suppose recompense to some of it might be recompense to affected individuals, if it's not taken you know, if the case is not taken civilly. But again, I'm only surmising, but I'll try and find out and let you know.
Perfect. And Louise has asked if a data protection assessment form can be sent with slides to everyone who's attended. And
yeah, I think that's a good idea. Why didn't I think of that?
Yeah, that sounds like a great idea. We can organise that. Thanks for asking, Louise. Perfect. I think that's it so far. If anyone has any questions, you can pop them in the box right now, or else we can give you a couple of minutes back.
Yeah. I maybe should have not drank so much coffee, and then we could have.
Coffee is always necessary for these things. There's always
and then I wouldn't maybe have spoken so quickly. But you know, you'll have the video and you'll have the slides. And
yeah, no, I thought it was fascinating. If you think of any
questions, you can email them to me.
Yes, so Fiona's email will be on the slide, or you can respond to the email that we'll be sending the slides with, and obviously the data assessment form that we will be sending out with this. Oh, we have another question. So where can we avoid data protection breaches? Oh, where can we find it? We will be sending it out.
The avoid data breaches document.
Yes.
That was from the data protection. Let me just run back and I'll show it to you. There, the Data Protection Commissioner tip for avoiding data breaches. It's on slide number 7. And if you go to their website and or Google it, it'll should pop up for you. It's
right.
There's another question there from Michael.
Yeah. Do you want to answer that there?
Yeah. So is there a danger that the data protection is considered weak, as we appear to have been told by the EU to impose the fine on Meta? Yeah. There is. It's not a danger. It's a real. Okay. So the Data Protection Commission keeps defending their corner, and they're doing a stellar job, but they're under-resourced for the size. I read a statistic. It was in actually a Dáil debate. It was a TD said that Ireland holds 40% of Europe's data sets, which is enormous for our size, you know, and for our commission size. So yeah, it's there's a swathe in Europe, including the European Data Protection Board, that thinks Ireland are not enforcing strongly enough.
And I think that might be all for today. Feel free to email us if you have any outline questions or after you read through the slides. And I want to thank Fiona for her time today for a really interesting and wonderful webinar.
Thanks, Mairead.
Yeah, perfect. And someone has agreed with me and said it was great. So perfect. Thank you all for your time. Thank you for joining us, and we'll see you on the next one. Bye.
Great. Bye. Thanks, Mairead.